TTIPill Lecture, the Jamboree network with the universities of Rennes and the University of Bologna. The project looks at the legal ambiguities underlying the TTIP that, as you know, is at the moment on hold, but you never know, we may come back. But more generally, we're looking at the problems that arise from investment treaties and investment arbitration, with specific regards to the European Union. Today we have our third event. We have Flavia Marisi, who is a research assistant at the Chinese University of Hong Kong, and also a PhD candidate at the University of Ghent. And she's writing a PhD on investment treaties, investment arbitration in relation to environmental issues. The topic of today is particularly important, as you may know, because the drafting of investment agreements has an incredible impact on how investment issues and disputes are solved. So, in fact, I was discussing with Flavia before about you may know, the Stockholm Treaty Lab. At the moment, there is a lot of discussion on how we might reform the investment system, investment treaty drafting and investment arbitration. And the Stockholm Treaty Lab is currently looking at new proposals for treaty drafting on environmental issues. So this is enough for me for the moment, so I leave the floor to Flavia. And thank you again, Flavia, and everyone for the attention. Thank you.
Thank you very much for this very kind introduction. So yesterday, we discussed the topic of transparency in investment arbitration. We defined it, we brainstormed the advantages of transparency, but also the advantages of confidentiality in investment arbitration. We analyzed the different provisions of transparency, and we analyzed 5 different cases where the application of these provisions was different. And this showed the different approaches of the investment tribunals. We also recalled the legal basis of investment arbitration. Does anybody remember that? What is the legal basis of investment arbitration? Where can we find the consent to arbitrate? In the treaty, yes. Thank you very much, exactly. So it is the treaty signed between the home state of the investor and the host state that opens for the possibility of investment arbitration through the provisions of dispute settlement. But let's take a step back today. First of all, what is an investment treaty? What purpose does it serve? Are investment treaties successful in achieving their goals? How are investment treaties structured? How can we draft an investment treaty? But even before answering these questions, we need to take one more step back. We know that investment treaties regulate foreign investment. But what is FDI and how is it different from foreign indirect investment? What are the statistics of FDI's inflows and outflows? So we will answer all of these questions today. I have another question for you. Can you give me a definition of investment? So you can see lots of money here. Probably it involves money. It is the collection of resources for a given period of time for future profits, involving capital flows from one country to the other. And this is why the word foreign investment. So it consists of greenfield investment or the merger of acquisition of a company. So what is a greenfield investment? It's the installation of a new establishment in the foreign country. So this means starting a company, a project from scratch. This is the so-called greenfield investment. Or it could also consist in the merger and acquisition of a company in the foreign country. But if there is merger and acquisition, we should remember that there should be both ownership and control and an active role in management of the foreign investor. How is foreign direct investment different from foreign indirect investment? What is foreign indirect investment? So it involves buying shares or positions in foreign companies to trade in the stock exchange. But substantially, why is it so different from foreign direct investment? Which one is easier to get rid of? So if we have shares, we can sell them the next day. While in foreign direct investment, the ownership of a project usually made for an expectation of return in 20 or 30 years, then we have a longer term of investment. Why is foreign direct investment important in the global economy? So FDI plays a very important role in financing development, economic development. It has contributed greatly to the economic development of different parts of the world and the general pattern of globalization. If we take a look at the statistics, we can see that in the 1990s, FDI increased of 20%, only in the first half of the 1990s, an increase of 40% in the 2000s. Let's take a look at the perspective of the investor. Why would an investor be interested in investing abroad? Any idea? So let's imagine having a project in a different state. Why would we do that if we don't really know the regulations of the country? Maybe we don't even trust the judiciary of that foreign country. But there are economic advantages. So for example, proximity to markets. We access a whole new market, that is the market of the host state. Access to raw materials. So maybe the raw materials that we need are not available in our host state, and this is why, in our home state, and this is why we need to have our investment abroad. Access to lower labor costs. So wages are an important cost for investing companies. And tariff jumping. So being already in the territory of the host state, we don't need to sell goods to the host state. And this means that for sure there's not going to be any tariff to pay. Moreover, the host state could have policies that attract foreign investment. And these policies can be, for example, in terms of tax, incentives to attract foreign investment. This figure shows the most important factors that companies choose when they decide where to make foreign investment. So at the first position, we find domestic market size. Is the service or product that we're going to produce sellable? Is there an opportunity in the domestic market? Second position, transparency of government regulations and lack of corruption. And this here refers to what we have mentioned yesterday about regulatory transparency. Are the laws and regulations of the host country transparent? Are they available? Are they published by the host country? Tax rates and ease of tax payment, general security environment, cost of labor, efficiency of legal and regulatory processes, government incentives for investors, and so on. So these are all the factors that companies take very well into consideration when they decide where to establish their projects. So we're always looking at foreign direct investment from the perspective of the investors. We saw why they do it. We saw what they take into account when they decide where to do it. But what are the risks of foreign investors? So number one, exchange rate risk. What does this mean? So this refers to the currency rate volatility, currency rate of the host state. Of course, if there is going to be a collapse in the currency exchange rate, then the investor is not going to be able to take home the same value of the profits that he was expected. Second, expropriation risk. Can the host state expropriate the investment? Can they directly take the assets of the investor? And if they can, is there a compensation to be paid to the investor? So this is another risk. And thirdly, regulatory risk. So we have already mentioned the fact that investment take place for a long duration of time. And in this time frame, let's say 20 or 30 years, what happens if the regulatory framework changes? So if the laws in the host country are modified in such a way as to affect the investment, negatively affect the investment, can the investor be compensated for this infringement of its legitimate expectations that the legal framework would be stable? So these are all the risks that investors take when they initiate a project abroad. So if we talk about foreign direct investment, it might seem a concept that doesn't really affect everybody's lives, but this is not true. Can you see anything in this slide that affects your everyday life? Some products that you use every day. What can you see? So a big part is represented by petroleum refining industries, and this is of course very useful for anybody. Petroleum has lots of uses. We see many of these companies produce motor vehicles, some produce communications, and there is also number 11, Anheuser-Busch from Belgium, food and beverages. Have you ever heard of this company? Maybe you haven't heard of this company, but I'm sure you have heard or even tasted its product. So its product are beers like Budweiser, Corona, or Stella Artois, or Beck's. So these are all products of this company. So here you see, why do we have these companies here? They are the world's top 100 non-financial multinational enterprises ranked by foreign assets. So this is why we can see that they produce products that we use every day. So now, after we have defined FDI, we are going to pass on to the problems of foreign investment. After that, we will move on to the second part of the class, regarding bilateral and preferential treaties, how they're structured and how we can draft them in such a way as to protect the interests of the host state. All countries seek to attract foreign investment. Do you agree with this statement? Is there any country that doesn't want foreign investment? Why do they want to attract foreign investment? So you can see a list of reasons. So growth, it helps the growth of these countries. Trade, technology transfer, competition, employment, it gives labor to the people of the host state, enterprise development, and proximity to markets. And how else, apart from concluding investment treaties, how else can countries attract foreign investment? So the agencies that you see here are agencies that are linked to each country and that aim to promote inflows of investment. So for example, Invest Hong Kong helps companies that want to invest in the territory of Hong Kong. Has the crisis of 2008 had any influence on global FDI inflows? So here you can see a significant drop from 2008 to 2009. But what happened after the crisis? So the global foreign direct investment inflows rose by 11% in 2013. And we can see a difference between the inflows to developed countries and to developing economies. So while FDI flows to developed country reached a low share that was 39%, FDI flows to developing economies reached the new high of 759 billion of US dollars in 2013. If you think of the FDI inflows, what are the top 20 host economies? And where does, for example, the United Kingdom stay? Does it appear in the top 20 host economies or in the top 20 home economies? So the United Kingdom appears in both lists. we can see here that it appears it gives more importance. There is more FDI inflows than FDI outflows. However, in the first positions we see United States, China, Russia, Hong Kong, Brazil. And for the inflows and for the outflows, United States, Japan, China, Russia, and Hong Kong. Now we come to a very important question. Should we regulate foreign investment? And why? Why should we regulate foreign investment? So here you can see three different pictures. The first picture is the port of Piraeus in Greece. Do you know who owns it? So China. This is a Chinese investment. Second picture, Nike factory. Who owns it? Nike. That's American. But this factory is in China. And Novotel, who owns it? That's a French company, but this hotel is in Hong Kong. So we can see in different sectors, tourism, manufacturing, infrastructure. FDI is in all of these industries. And it is particularly sensitive when it comes to infrastructure. When we have foreign ownership of crucial strategic infrastructure, such as ports or airports or highways, roads that are often built by other countries, then there can be some situations of national sensitivity. And this is why it is important to regulate foreign investment. So on one side, FDI promotes several positive spillovers, but these benefits are not automatic. And they depend above all on the policies of the host country. And on the other side, FDI is also associated with potential downsides. So for example, the risk of corruption in the host state, or the risks related to the environment of the host state following the investment project. Also, another downside could be the deterioration in the balance of payments. Why? Because the profits of the investor are repatriated. So what is the balance of payments? So it is a statement that summarizes an economy's transactions with the rest of the world for a determined period of time. So these are the benefits, these are the downsides. So what should investment treaties do? What is their role in this context? So the challenge for investment treaties is to maximize the benefits and minimize the costs. I have another question to you. For trade, the global organization that we look at is the World Trade Organization. Is there any correspondent in the world of investment law? No. Not yet. Not yet. Great answer. Yes. Should we have one? That's a good question. Should we have one? Would it bring advantages to the regulation of foreign investment? This area of economic law is extremely dynamic. Why? Because at the moment, there are more than 3,000 international investment agreements. whose provisions might be different from each other. So international investment agreements, they're treaties concluded by 2 or more states. They are part of public international law, but they have impact on private entities. So international investment agreement is a broad category. Why? Because it includes different types of FDI-related treaties with different names. Let's see what they are. So the BITs are the bilateral investment treaties concluded by 2 parties, and it only addresses investment. PTAs, it's the acronym for preferential trade agreements. So for example, NAFTA, I'm sure you have heard of it, or ASEAN, the Australia-China of 2015. And in PTAs, there can be a chapter on investment, but only a minority of them cover investment. And then we have the multilateral agreements, like the ICSID. We will discuss further on what the ICSID is in the multilateral agreements part. Now, we come to the part on bilateral and preferential treaties. What is the role of BITs and PTAs? So international investment agreements contribute to the creation of a stable, predictable, and transparent regulatory framework for international investment. In this way, they strengthen the enabling framework for FDI. What else do they do? They facilitate the coordination of investment relations through internationally agreed common denominators. And they regard the relations between host states, home states, international investors, but also other development stakeholders. And moreover, they complement national laws on investment, and they serve as an interface between national and international investment policies. Here you can see the trends in international investment agreements signed. If you just look at the bars, you might think that they are decreasing, but this is just how many new agreements are signed every year. Because if you look at the gray line, the one regarding the cumulative number of international investment agreements, you see that it continues to rise. And now we have roughly 3,000 international investment agreements. If we have to summarize the arguments for and against the presence of international investment agreements, we can see that in favor of them, we find the contribution to a favorable investment climate. This is what they serve. This is the purpose that they serve. They want to contribute to a favorable investment climate in order for the host state to receive more foreign investment. They contribute to fostering and expanding economic and political cooperation between the contracting parties. They contribute to the stability and predictability of the policy framework, foster good governance, and the rule of law. Remember here the stability and predictability of the policy framework. This is very important for the investor. They provide protection rights that are independent from host countries' domestic legislation. Why? This is a basic concept of international law. It attains to the superiority of international law over national law. But we can also ask ourselves, since there is customary international law, can't investors just base their rights on customary international law? Well, if these provisions are written in a treaty, then of course the legal certainty will be higher. These treaties reduce political risks of investing abroad. They may facilitate the granting of investment guarantees by the home state of the investor, and they help to avoid politicization of investment dispute, thanks to the ISDS provision in the treaty. However, there are also some arguments against the existence of international investment agreements. For example, they do not guarantee additional investment inflows. This is a contradiction. Didn't we say that their aim is to contribute to a favorable investment climate? Yes, but we can make the example of Brazil that doesn't have international investment agreements. And despite this, it has inflows of investment. Moreover, they may negatively affect host countries' sovereign right to regulate in the public interest. This point in particular is really interesting for host countries because sometimes they might fear that a change in their regulation might affect the investor, and they might fear that they will be brought before an arbitral tribunal. These investment agreements also they expose host states to ISDS for the reasons that we have just explained, and the associated financial risks. So in investment arbitration, if the arbitral tribunal decides that the host state has breached the treaty, then it might award compensation that usually amounts to millions of euros to the investor. Also, these investment agreements privilege foreign investors over domestic investors. Can this be possible? Can foreign investors be treated better than national investors? Yes, we will see later on in this class how precisely foreign investors can find themselves in a better situation compared to domestic investors. Moreover, these types of agreements provide only for investors' rights and not obligations. They reflect a negotiated outcome that is influenced by the bargaining power of the negotiating party. This is very important when it comes to the negotiation of an investment treaty. We have 2 or more countries that are negotiating the different provisions. But how much bargaining powers do they have? Especially if one is a huge economy and the other one is a developing state. Do they have the same bargaining power? Do they have the same voice in deciding what provisions should be added to the treaty? Also, the investment treaties may result in overlapping and inconsistent investment agreement obligations of contracting parties. Yes. So the same parties might have overlapping or inconsistent obligations based on the investment agreements it is party to. Also, they are difficult to amend in case of changing circumstances. What is the EU doing in all of this? What is the state? So we see from this slide that was tweeted by DG Trade. We see a map of the world with the pending negotiations, for example. And we see that the EU is negotiating with lots of countries. So it is obviously a priority. Now, we pass to the second part of this class regarding the single provisions in international investment treaties. So the key provisions in BITs and PTAs can be differentiated based if they are reducing, if they are restricting the possibility of the investors, or if they're building the rights of the investors. So in the restrictions part, we find the provisions of entry and establishment. We find the provisions of ownership and control, the operational restrictions, and the authorization and reporting, all these obligations, etc. What do we find in the standards of treatment and the protection? We find different types of treatment. So national treatment, most favored nations, and fair and equitable treatment. We find the provisions of expropriation and compensation, and then transfer of funds, dispute settlement, transparency, and so on. What is the structure of an international investment agreement? And how can we group the different provisions in a different way? So first of all, some provisions define the breadth of investment agreement. What are these provisions? The definition of investment, how broad it is, the temporal scope of application, how long it applies for, the umbrella clause. We will see what the umbrella clause is for. And then some provisions that attain to the liberalization of foreign investment flows. So they pertain to the scrutiny level that the host country wants to have when admitting foreign investment, when allowing for cash to be transferred abroad, and when the host country wants to keep its environmental and labor standards at a certain height. Another type of provisions are the anti-discrimination provisions, and we can find them in the most favored nation and the national treatment. Then we find the regulatory constraint. So how much, to what extent is the host country allowed to regulate in such a way that its measures affect the investment? So the provisions of expropriation and fair and equitable treatment, they achieve this aim precisely. And then finally, the access to international dispute settlement. Is there a way to solve disputes under this treaty? Do all the investment treaties have an ISDS clause or no? So let's start with the definition of investment. So I would like to give you these papers. Because I would like to reflect with you today on different provisions in different treaties. I would like to look at them and see what is the wording and the phrasing of these provisions and how they affect how foreign investment is regulated. So for example, the definition of foreign investment, why is it so important? Well, of course, the definition of foreign investment is the most important provision because it determines the scope of application of the treaty. If a certain types of investment do not fall under the category of investment, under the definition of investment as defined within the treaty, it means that they will not be protected by the treaty itself. And if they're not protected by the treaty, it will mean that the investor will not have any access to ISDS if the latter is provided for in the treaty. So if you have a look at the definition of foreign investment in these different IIAs, what can you find? So, for example, many definitions of investment are asset-based. So, for example, in Hungary, Bulgaria, BIT, the term investment means every kind of asset. And how are assets defined? These assets shall refer to all direct investment made in accordance with laws and regulations in the territory of the contracting party. So, for example, here at the beginning they say every kind of asset, so it's asset-based definition. But then these assets shall refer to all direct investment. So it already tells us that it's only regarding direct investment. What about the Hong Kong, Austria, BIT? So also this definition is asset-based. And it lists 5 different categories of material and also immaterial assets. Where do we find immaterial assets? Any ideas? We are in the Hong Kong, Austria, BIT. For example, intellectual property rights is an immaterial asset. What about the definition of its investment given by the USA Bahrain BIT? What does it mean? Investment as every kind of investment. It's a tautological definition. What does it say? What do we understand from this? If it is a tautological definition, it means that it cannot be broader. It cannot be broader than this. So, but it is useful because we understand that this definition is flexible. So it can apply also to future types of investments. And this, the USA Bahrain BIT, is opposite of NAFTA. Why? What do we find in NAFTA? So what is the peculiarity of NAFTA, of the investment definition in NAFTA? So in NAFTA, it's a closed list. So what does this mean? It means that if your type of investment does not fall under one of these mentioned categories, then your investment will not be protected by this treaty. So we talked about the definition of foreign investment. Let's move on to treaty duration. So we're talking about the temporal scope of application. So in order to ensure protection and a stable investment environment, the treaties are conducted for a minimum duration of time. Usually this duration is minimum 10 years, but also there could be investment agreements that have a longer duration. Is it possible to terminate a BIT? This is a real question for you. Is it possible to terminate a BIT or an investment treaty in general? Yes. Usually with a certain duration of notice. So for example, 1 year notice. So we can imagine if the treaty has a longer duration than 10 years, or then even if it extends its scope of application also to investments made before the entry into force of the investment, then it will have a more favorable impact to foreign investment. The termination notice is also called sunset clause. Let's move on to the umbrella clause. Does anybody know what it is? So the particularity of the umbrella clause is that it can elevate a contract claim to a level of a treaty claim. So here we have to imagine the situation where the investor signed a treaty with the host state. If the host state breaches one of the provisions contained in the agreement, in the contract with the foreign investor, does this mean that it breached the treaty? It depends. On what?
On the treaty, on the way the provision has been written.
Yes. If there is an umbrella clause, this is exactly the purpose of the umbrella clause, to elevate a contract claim, so the case where the investor, the state has breached a contractual provision with the investor, it raises this contract claim to the level of a treaty claim. And if it is a treaty claim, then the investor will have access to ISDS based, of course, on the provisions of the treaty. But why? Why is it so important? Because usually, if you violate a contract, this doesn't automatically invoke treaty protection under international law. It's just a breach of contract. It's not an automatic treaty violation. But if there is an umbrella clause, then it can be. So now I would like you to read these 3 umbrella clauses and tell me your thoughts about them. So do they offer the same level of protection to investors? This is a real question. Please give me your thoughts.
I don't think so.
Okay, why?
I think the first one, German, Pakistan, BIT, is probably the broadest one because it just says shall observe any. So I think any is quite capacious and might include under its umbrella many contractual claims.
Mm-hmm.
Whereas the other two are quite specific, especially the Singapore Czech Republic definition, because it lists which commitment and it specifies the scope of the umbrella clause. So in my opinion, it's much, much narrower.
Exactly, yes. Thank you very much. Yes. this is how the different provisions are phrased. Of course, it has an impact on the breadth of these provisions and on the type of protection that is given to the investors. In particular, the Singapore Czech Republic, BIT, has a specification. So it specifies each contracting party shall not interfere with any commitments entered into by nationals or companies with the national or companies of the other contracting party as regards to investment. So, now that we have dealt with all the provisions regarding the breadth of investment agreement, now we're going to move on to the part B about liberalization of foreign investment flows. First of all, the entry of foreign investment. Has anybody heard of this term? So the entry of foreign investment can be regulated according to two different models. One model is called the admission clause, and the other model is called the right of establishment model. So why is it important historically? So historically, territorial sovereignty allows a state to prohibit the admission of foreigners and to deny the right to settle within its territory. What does this mean? The host states have the exclusive authority to decide whether the investment may be allowed in its territory. So the host state decides whether to admit it. But if the host state admits the investment, what does this mean? It means that the investment will be subject to the protection offered by the treaty. So here you can see also in the papers that you have two different types of provisions. The admission clause is expressed in the Hong Kong-Austria agreement, and it reads, each contracting party shall encourage and create favorable conditions for investors of the other contracting party to make investments in its area, and subject to its laws and regulations shall admit such investment. What do we find here that is noticeable? So it grants the investors the right to be admitted subject to its laws and regulations. So this is the condition, subject to the host country's laws and regulations. This means that the country has to have a law or a regulation that regulates the admission of foreign investors. So this is a formal requirement. How is the admission clause different from the right of establishment model? If you have a look at it, can you tell me how is it different? Any ideas? How is the admission clause different from the right of establishment model?
I would say that without an admission clause, the host state retains control in respect of the establishment, so it can choose whether to admit an investment and on what terms.
Yes, very good. And what about the right of establishment? Yes, exactly. Yes. So while, yes, that's absolutely correct. So while in the admission clause, there is, you see here, it's subject to its law and regulations. What do we notice in the right of establishment model? So here we see each party shall permit and treat such investment and activities on a basis no less favorable than that accorded in like situations to investments of its own nationals, this is the NT, this is national treatment, or of nationals or companies of any third country, this is MFN, most favored nations. So here, the right of establishment is based on national treatment and most favored nations. So this is a comparative standard. Now, we move on to the transfer of investment-related funds out of the host state. So why is it important? What is the transfer of investment-related funds out of the host state? You can guess. It's profits, right? What profits?
From the investment.
Yes, the profits from the investment, very well, that the investor has gained. What does the investor the question is, can the investor freely transfer its profits to its home country? Is there a cap, for example? So usually, the transfer of funds has to be made without delay and typically in a freely convertible currency. So let's read these different investment treaties and let's see how they regulate the transfer of investment-related funds. So let's start with the first one, Austria, Hong Kong. Can anybody read it out loud? Do we have a more participative class?
Marisi, you're right. I cannot really see this.
I have this paper.
I get it. Thank you.
Of course. It is the transfer of investment-related funds. You can see it on page 2.
So, it's just right to transfer approved the investments and the funds. The same VAT in Article 7.2 clarifies that investors shall also have the unrestricted right to transfer approved in particular, but not exclusively. Transfers of currency shall be effected without delay and freely convertible currency.
Mm-hmm. So what do we notice here? What are the adjectives that immediately pop out?
Unrestricted?
Unrestricted, excellent. Unrestricted. Okay, let's compare it to the Portugal, Bulgaria.
Okay.
Please read. Please read, please.
The host state is free to limit the flow of capital out of its economy as long as it is done through law. So I will say that this is not unrestricted.
Exactly.
When was the Portugal Bulgaria signed?
I don't have it on the slides.
Uh,
Yeah, it's an intra-EU bit.
exactly.
Yes, but we're just talking about it from the point of view of the provision drafting. What about UK, Argentina?
Exception to the free transfer of funds are allowed only during balance or payment difficulties when such restrictions are necessary, non-discriminatory, and on a temporary basis.
Very well. What do we understand here? So they are allowed, but on certain conditions, only in a certain situation actually. The situation is during balance of payments difficulties. When such restrictions are also in this situation, there are even more conditions. When such restrictions are necessary, non-discriminatory, and on a temporary basis. So these are all the limitations to the exceptions to the free transfer of funds. Why? Mm-hmm.
So, if that, or is it referred to the host state?
Yes, the host state, yes.
So the host state in economic difficulty can prevent foreign investors from free transferring revenue. So it's just surprising that NAFTA, well, this is something that I would see written by Mexico, but how about Canada and the United States? How can they accept something like that?
If they accepted it. If they accepted it, obviously they have.
Yeah, they have accepted it. Yeah, so I don't see how they have accepted it because the only country you can actually find themselves, but more likely find themselves in that situation is Mexico. So basically, Mexico is free to just say, well, too bad, we're in default.
Well, what is interesting here is economic difficulties. Is there a definition of economic difficulty?
Plus, economic difficulties is not bankruptcy or default.
Exactly. There is no.
It's like, oh, sorry, this year we're not really able to meet our energy targets, so you know what, we're giving you money.
This is very interesting because if the economic difficulties, if it is not defined by the treaty, who has the power to define it?
Arbitrators.
The arbitrators.
But
Yes.
arbitrators usually, okay, now I can see how the system develops because arbitrators usually find in the US.
Well, what we can say in general is that yes, if the definition, if the term is not defined within the investment treaties, if it is too broad, then it certainly will be defined by the arbitrators. This is what we can say. And we can certainly say that here the expression economic difficulties is extremely broad. This is what we can say. What does it mean, restriction on capital flights, that appears in the Chile-Austria protocol?
Many of the flights sounds to me like something that is just take your money from.
Yes, exactly. So here it refers to large exodus of financial assets. So here there are restrictions on short-term capital in and outflows. So yes, the image that you pictured us is pertinent.
And it is something that protects Chile, so.
Could be, yes, could. But this is all pertaining to the bargaining power of the countries within the negotiation process. So if
What strikes me is that
maybe Austria obtained something that Austria wanted in another part of the treaty, if Chile obtained the provision that it wanted regarding the transfer of funds, this is the negotiations game. Okay, so let's move on to environmental and labor standards. Have you ever heard of environmental and labor standards being included in investment treaties.
European Union's got entire protocols on environmental standards, sustainable development, labour standards.
And is it included in investment treaties?
It is included, yes. Yes, it is included well in the protocol and in different provisions, and then there are the protocols attached. But there is a caveat there.
Why?
Sustainable development protocols, environmental standards, protocols are not subject to the same dispute resolution system as every other provision and chapter in the treaty. So, whereas there are binding dispute resolution mechanisms in investment chapter and all other trade chapters, for sustainable development and environment, there are consultations.
There is a very interesting caveat there, I see. Yeah, so let's see. The main difference that we can notice if environmental and labor standards are present in the preamble or in the text of the agreement. So what is the difference according to your opinion?
Between preamble and text.
Yes.
Someone once said that when you have nothing else left, look at the preamble. So I would say that it's much more important to look at the text.
Yes, it is much more important to look at the text, yes. When can we use the preamble? What does it mean? What somebody said, when you have nothing else left. In practical terms, what does it mean?
When you need to interpret one provision in the sense of the other, look at what the preamble said. And we saw that in arbitration, investment arbitration class. So preamble is really important, always to look at when you need to
Interpret, yes.
Provision is usually when it has a nice draft, it's usually binding.
Yes, yes, that's the key. In the text, it is the provision has much more strength than the same provision recital in the preamble. So here, let's read the Netherlands Model BIT of 2004. Can I have any one of you reading?
The Netherlands. Considering that these objectives can be achieved without compromising health, safety, and environmental measures of general application.
And what does Norway Model BIT say?
That the parties recognise that it is inappropriate to encourage investment by relaxing domestic law, safety, or environmental measures or core labour standards.
Please continue.
The parties recognise that multilateral environmental agreements to which they are all party play an important role in protecting the environment. The parties should continue to seek means to enhance the mutual supportiveness of multilateral environmental agreements.
Okay, so what do you think about these provisions? What is the verb that is used in these provisions? In all of them, all of the three provisions included in the text.
And safety environmental measures.
The verb is recognize. The verb is just they recognize. Parties recognize that it is inappropriate, or the parties that multilateral agreements play an important role, or again, they recognize that it is inappropriate to encourage investment by weakening the protection of environmental laws. So this, what we can think of environmental labor standards is that there are some regions that push to have them, and also they will push to have them in the treaties that they are negotiating in the future. So we will probably see them more and more often in future investment agreements. Now, let's move on to most favored nation. So first of all, where does this provision come from? Most favored nation.
Trade law
From trade law, yes. Where exactly? Where can we find it?
and the GATT, for example,
Yes. And how does this provision work?
that you cannot treat one country more favorable than another if you're under this obligation. Otherwise, it's free for you to discriminate.
Yes, very well. So it requires each contracting state to accord to investors of the other contracting state treatment that is no less favorable than the same treatment accorded to the investor of third states. So this is the MFN standard, and it establishes a level playing field with all foreign investors. So this MFN treatment requires that the government does not discriminate. This is one of the two provisions of non-discrimination. That the government does not discriminate between the investors of that particular country compared to the investors of third countries. Let's have a look of the provisions. We have 5 different BITs to look at. So Hong Kong, Austria, Article 4. Can I have a volunteer reading it?
You go.
In all matters subject to this agreement.
Oh, that's Argentina, Spain.
Sorry.
Can I have you read Hong Kong, Austria?
Okay. Sorry.
No worries at all.
Another obligations shall not apply so as to require the host state to match any benefits resulting from any arrangement designed to lead to original customs, monetary, tariff, or trade arrangement, or from any arrangement with any third state in a region designed to promote regional cooperation in the economic, social, legal, industrial, or monetary fields within the framework of specific projects.
Okay, so what do we understand here? So this is something that was added to the MFN provision. So there was the MFN provision and then this sentence later. So it's a limitation of the scope of application of the MFN provision. What does it say in practice, this sentence? What does it tell us? So here, what are the words that really make us think? What are the key words here? What is the protagonist of the, sorry, please. So here we see regional, customs, monetary tariff or trade arrangements, right? This is the key, this is the protagonist of this provision here. And this is a limitation. So MFN obligations shall not apply so as to require the host state to match the benefits that were already accorded to other parties to a regional integration, different types of integration. So what does it mean? It means that MFN does not want to be an impediment to regional integration. Okay, can I have somebody reading the Argentina-Spain bit?
In all matters subject to this agreement, this treatment shall be not less favorable to that extended by each party to the investments made in this territory by debtors of the third country.
Is it broad or is it very narrow?
Well, it's too broad.
It's broad, very broad.
Talk about the no reference to customs
Yes, yes, it is very broad. What about the one between Japan and Malaysia? Please.
Okay, each country shall accord to investors of the other country into their investment treatment no less favorable than fact it accords in like circumstances to investors of the third state and to their investments with respect to investment activities. Establishment, acquisition, expansion, management, operation, maintenance, use, possession, liquidation, sale, and further disposition of investments. So the like circumstances, I guess, tightens this provision.
And also investment activity.
Yeah, exactly.
The like circumstances is standard, but what limits the scope of the MFN clause here is the close list of investment activities.
Well, in some cases, like circumstances, has been foreseen as a limitation to also MFN clauses, to the scope of MFN clauses, because without like circumstances, some arbitrators apparently have even no less favorable of other investors, despite, even though like circumstances should be the standard because it's the used in generalist test. In some occasions, it could be interpreted as all the treatment is being given to other investors, whilst despite the exact discrimination that's being given to the investor. So, well, I don't think it really makes some sense because it seems obvious that you should look at the same discrimination, same exact case. So if you're being discriminated for access to, I don't know, public activity, public service, that should be, you should look at what other investors, how other investors are being treated with respect to the same activity. But apparently, there have been cases about everything probably, there have been cases in which like circumstances, with the absence of like circumstances has been seen as an even like much broader has given an even much broader interpretation to the MFN clause.
Of course. Or even the expression similar circumstances. Is like circumstances, does it have the same meaning of similar circumstances? Of course, every single word that is added or subtracted by the text can broaden or the scope or make it more narrow. So, let's read the Japan-Switzerland EPA.
If a party accords more favorable treatment to investors of one party and their investments by concluding or amending a free trade agreement, customs union or similar arrangement that provides for substantial liberalization of investment, it shall not be obliged to accord such treatment to investor of the other party and their investments. Any such treatment accorded by the party shall be notified to the other party without delay, and the former party shall endeavor to accord to investors of the latter party and their investments treatment no less favorable than that accorded under the concluded or amended agreement. The former party, upon request by the latter party, shall enter into negotiations with a view to incorporating into this agreement treatment no less favorable than that accorded under such concluded or amended agreement.
So what do we understand from this provision here? So here we can say that the MFN is an MFN with restrictions. Why? Because it does not apply to third treaties, providing for substantial liberalization of investment. What about the Australia-Uruguay bit? But we can see that there is a difference. So in the first part of the sentence, it's talking about each party shall at all times treat investment in its own territory. And this is the first part. And then it says, on a basis no less favorable than that according to investments of investors of any third country. So in the first part, the word investors does not appear. So it seems that as there are some provisions that can be applicable only to investors themselves and not to investments, then the investors are not part of this MFN clause. So if we think, for example, of some discrimination related to the establishment of certain investors.
So it applies, so this is like so you say that the MFN applies not to the establishment provision, not to establishment moments, but only to the actual investment from the moment when it's established.
Yes, it applies only to the investment and does not apply to the investor. So we have to think what could the provisions, what provisions could be applicable only to the investor and not to the investment. So we can think that these provisions are those applicable only once the investment has been established.
So it's not liberalization, it's only protection.
Exactly, exactly, exactly. So we have talked now about MFN. Now let's move on to NT. NT stands for national treatment. Very well. And what does it say? So foreign investor is accorded a treatment not less favorable than that which the host state accords to its own investors. So this is the principle of non-discrimination compared to the situation of the domestic investors. So is it a mutuality obligation? Is it a reciprocal obligation? So you treat country A, you treat your domestic investors in this way, so country B has to treat its foreign investors in the same way. It refers to the treatment of country A to its domestic investors and to its foreign investors. What are the types of provision and wording that we can find here? So we can see the word same, so the treatment should be the same, or as favorable as, the treatment should be as favorable as, or the treatment should be no less favorable. What do you understand from here? If the treatment is no less favorable, what does it imply? If the treatment of foreign investors is not less favorable than the treatment of domestic investors. Yes, exactly. The host country could treat foreign investors in a more favorable way. And this links to the discussion that we had just a minute ago in the MFN clause that applies to like circumstances or similar circumstances. So let's take a look at the Russia-Lithuanian anti-provision. Can I have somebody read it?
Each contracting party shall accord in its territory to the investors investments made by investors and the other contracting party and activities related to such investment fair and equal treatment. The treatment set forth in the paragraph 1 of this article shall be at least no less favourable than the treatment accorded to the contracting party to the investments and activities related to such investments of its own investors and the investors of that state.
Yes, can you please continue to the Russia-Sweden?
Yes, each contracting party may have in its legislation limited exceptions to national treatment provided for in paragraph 2 of this article.
Okay, so how can we comment on these two different provisions?
In the first provision, as we talked about a few minutes ago, it's possible to treat for investments in a favourable way.
Yes.
Whereas in the Russia-Sweden situation, there are some exceptions to the national treatment standard. So I interpret this as you may, in some circumstances, discriminate for anything.
Yes. Yes. Provided that this discrimination happens where? In its legislation. So it has to be, from the formal point of view, it has to be an adopted law. Very well. So why is it so important to draft carefully the NT and MFN provisions? Because right now, as we have roughly 3,000 international investment agreements, all of them have different wording of NT and MFN. And the scope of extent of the protection offered by these clauses can vary differently under one treaty as compared to another treaty. Now, we come to the provision of expropriation. Now I have a question for you. Can the host state expropriate the investment? Is it a right? Yes. Yes, it can. Are there any conditions for expropriation to take place lawfully? Yes. Mm-hmm.
Some treaties, so it has to be, for example, for a public purpose, or
Yes.
so you can't do like at your will, like
Yes, absolutely, absolutely. This is why is it so important to talk about expropriation? Because historically, expropriation represented the major risk for foreign investors when they were starting their operations abroad. So the expropriation is lawful if it satisfies these conditions. So it has to be for a public purpose, it has to be non-discriminatory, and it has to be followed by prompt, adequate, and effective compensation. These requirements, they are believed to be part of customary international law. So what does prompt compensation mean? It means without delay. What about effective compensation? It means that the payment should be made in a convertible currency. And what about adequate? What does it mean? For its loss? But what about the never happened profit?
Well, it depends on state legislation and the circumstances. So yeah, theoretically you should also include the profit, but then you could ask how much profit should be compensated, because profit is not always
of the market value of its investment. Yes, but these are all legitimate questions. So should the lost profit be part of this calculation? Calculating the amount of compensation is really not an easy task. And then which moment should we take into consideration? Should we calculate damages based on the market value of the investment when it was expropriated? Or should we aim at the restoration value? Another question, should the compensation be at the same level if the other two requirements are met compared to the situation when the other two requirements are not met? And with the other two requirements, I mean the public purpose and the non-discrimination. So if an expropriation has taken place without public purpose and or with discrimination, should the compensation be higher in this case because it was an unlawful expropriation? So here we can differentiate between direct expropriation and indirect expropriation. Direct is the actual physical taking of property, but nowadays it's very rare. Nowadays what happens is the indirect expropriation, which points to the effective loss of management, use or control of a significant depreciation of the value of the assets of a foreign investor. So what are these criteria? The degree of interference with the property right, the character of governmental measure, the purpose. We have already seen the public purpose that it has to have in order for it to be legitimate, and the interference with reasonable expectations of the investor. So if we take a look at the provisions signed, for example, in treaties by France or the UK, Sweden, the US, or Italy, we find different wording in the provisions of expropriation. Can I have somebody read it?
Matters of expropriation or nationalization or any other matters the effect of which is the direct or indirect possession. Matters having effect equivalent to nationalization or expropriation. Misleading. Any direct or indirect matter or any other matter having the same nature or the same effect against investments. Former U.S. model PIT. Matters tantamount to expropriation or nationalization. USA. Any other matter or serious matters, direct or indirect, tantamount to expropriation, including the levying of taxation, the compulsory sale of all or part of an investment, or the impairment or deprivation of its management, controller, economic value. Italian. Indirect expropriation is not covered.
Okay, very well. So what do we see here? What are the expressions that we can link to an indirect expropriation?
So it would be direct and indirect dispossession, equivalent, same nature, same effect, and tantamount to.
Exactly. So here we can see the different wordings that are pointing to indirect expropriation. Okay, so now we can move on to the fair and equitable treatment. The fair and equitable treatment, has anybody heard of this provision before? This is an absolute standard of treatment together with full protection and security. And it is the most important standard. Why? Because in practice, with the known 817 cases, out of which 528 are concluded and 278 are still pending, out of them, the FET was allegedly violated in the main part of them. And precisely in the ones that have been concluded, it was found as a breach in 110 out of 159 breaches of investment treaty provisions. So it is the most successful provision breached in investment arbitration. And why is it? This is why it is so important. If we take a look at how it is drafted, in some cases, we will see that it's extremely vague. How does it read? Each party accords fair and equitable treatment to the investment of the other party. For example, here in the German Model Investment Protection Treaty, it is coupled with the full protection and security. It is part of the same article. Each contracted state shall accord investment by investors fair and equitable treatment as well as full protection under the treaty. And Australia-Hungary, a contraction party shall ensure fair and equitable treatment in its own territory to investment. So what do we understand here? It's very, very broad. Is it defined what fair and equitable treatment means? No. What is fair? What is equitable? What is fair and equitable? What we can see here is the evolution of the standard of fair and equitable treatment. So in the Columbia United Kingdom BIT, if I have a volunteer read it, it would be great. Yes.
Another one as well. Okay, each contracting party shall accord fair and equitable treatment and full protection and security in its own territory to the investments of investors of the other contracting party. For greater certainty, the concepts of fair and equitable treatment and full protection and security do not require additional treatment to that required in accordance with international law. Fair and equitable treatment includes the prohibition against the denial of justice in criminal, civil, or administrative proceedings in accordance with the principle due process embodied in the main legal systems of the world. The determination that there has been a breach of another provision of this agreement or another international agreement does not establish that the obligation to accord fair and equitable treatment has been breached.
So what can we conclude?
The number of clauses are not necessarily that bad. I mean, unless you have to read them. But they can offer like higher protection, and this is also why all the new technologies that are now getting longer and longer because they include a number of definitions and caveats in order to avoid or at least narrow down differentiation.
But to me, this feels like a clarification of the fair and equitable treatment standard itself. For example, denial of justice is part of that, so it's really, to me, feels like they were trying to clarify the situation. Of course, to avoid having disputes.
Mm-hmm.
But does, in your opinion, does this clarification bring anything new to the code?
Yes. So first of all, what is very important to see is that, so clarification, it is a clarification, but does not necessarily mean that the scope of protection is increased. So this is a very, very important point to where we can stay a little bit. Why? So here we see, for greater certainty, A, the concepts of fair and equitable treatment and full protection security do not require additional treatment to that required in accordance with international law. So it is the international law that we should look at. So, and this is something that sometimes is referred to in standards of treatment in international treaties, the customary international law. And, but what is customary international law? Yes, so yes. And does this mean that it is broad or that it's narrow, or does it mean that it's stable or that it changes? So it can change because state practice, accepted state practice, it changes throughout the time, and there are, and it needs also to be interpreted, and people need to decide what is part now of customary international law and what is not part of it. So this is the first clarification, letter A. And then letter B, it says that it includes the prohibition, fair and equitable treatment includes the prohibition against the denial of justice. So it includes, but it's not an exclusive list. It does not say it is only the denial of justice. It says the denial of justice is also part of the fair and equitable treatment. Let's make a step further with the Vietnam-EU FTA. The Vietnam-EU FTA has a beautiful FET provision. Can I have a volunteer read it?
Each party shall accord fair and equitable treatment and full protection and security to investments and investors of the other party in its territory in accordance with paragraphs 2 to 7. A party breaches the obligation of fair and equitable treatment referenced in paragraph 1, where a measure or series of measures constitute A, denial of justice in criminal, civil, or administrative proceedings. B, fundamental breach of due process in judicial and administrative proceedings. C, manifest arbitrariness. D, targeted discrimination or manifestly wrongful grounds, such as gender, race, or religious belief. Or E, abusive treatment, such as coercion, abuse of power, or similar bad faith conduct. Or F, a breach of any further elements of the fair and equitable treatment obligation adopted by the parties in accordance with paragraph 3 of this article. Treatment not listed in paragraph 2 can also constitute a breach of fair and equitable treatment, where the parties have so agreed in accordance with the procedures provided in Article 10.6 Amendment.
Thank you.
They are defining for the first time fair and equitable treatment.
Yes.
So they take it arbitrary practice and they put it into law, and so that you leave much less scope to arbitrators to decide what fair and equitable treatment is. You can actually foresee where you're going to be liable or where you're not.
Yes, exactly. And is it advisable that you can foresee?
Yes, of course. Well, for one, it makes disincentive litigation, so you have less litigation, because the issue in investment arbitration is also that litigation is most times used as a threat to the state, even when investors don't have really grounds for that. Only the threat of litigation can be a tool to influence state practice. For instance,
Absolutely, yes.
principle.
Yes, the promotion of certainty in international law is an objective to pursue, absolutely. So yes, in the Vietnam-EU FTA, we see a very delimited scope of FET, and we see how this is an exclusive list. So what the behavior of the party that breaches FET has to be part of these behaviors described in the article. Finally, we come to access to international dispute settlement. Is it something that is present in all international investment treaties?
Not in the regional ones and not in all transit ones.
So, for example, it's very important regarding the presence of international dispute settlement provisions to take a look at the history of Chinese BITs. Because in Chinese BITs, we can see how China has not been a big fan of investment arbitration. We can see, for example, the first BIT that China has concluded with Sweden in 1982. There was not even investment arbitration, but there was a state-to-state dispute settlement. Later on, in 1987, in China, Sri Lanka BIT, there was the possibility of investor-state dispute settlement, but only regarding the amount of compensation resulting from expropriation, while all the other disputes, all the other claims could not have access to a method of dispute resolution. And now China seems to be more open to resolving its dispute in investment arbitration. So this is why the presence of an ISDS clause is not to be given for granted, and of course the way it is drafted can have a huge impact on the access that the parties have to investment arbitration. If there is a mandatory period of 6 months for amicable consultations, of course, this limits the access to investment arbitration. So I would like to thank you today. We have talked about foreign direct investment, about the reasons for investors to invest abroad, and for host state to welcome investment. We talked about FDI statistics and why is it important to regulate FDI. We talked about different types of international investment agreement. And then in the second part of our lecture, we focused on the key provisions included in an international investment agreement. And this is the end of our class today. So I would like to thank you very much for your presence, for being so participative. Please, if you have any questions, do not hesitate to write to me. Thank you very much.
Thank you, Flavia. Thank you, everyone, for being here today. Very interesting class. And all the slides are going to be on the TTIP website. So visit it. We have lots of events. We have lots of conferences and calls for paper. So you will find everything on the website. Thank you again.